Oh my god. I'm in the middle of making part 3 of the verdict slips rabbit hole video, watching Melanie Little and Andrea Burkhart, and suddenly Andrea Burkhart says that the assistant district attorney is one of the lawyers in the federal case. Like, what the? Come again? So go back over to the Massachusetts federal government court website and pull up a motion by the respondent, and sure enough, it's signed Norfolk County Superior Court by its attorney Andrea Joy Campbell, Attorney General, and then underneath her by Caleb Schillinger. He's appointed as Special Assistant Attorney General, but his actual position is Assistant Norfolk District Attorney. You're probably wondering why I'm freaking out over this. It's not just because it's a conflict of interest. I mean, yeah, the fact that Andrea Campbell is the designated attorney for the Norfolk County Superior Court, it does not cure the fact that the state prosecutor, DA Michael Morrissey, whom Caleb Schillinger is an assistant to, is the very party who is litigating against the defendant in the state court. And sure, that's your conflict of interest part, which is very weak. If Andrea Campbell wants to explain it away as having appointed him as an SAAG, the problem is we have ex parte communications issues with the DA, and we still don't know if he's been colluding with Judge Bev. We know he's been colluding with other judges in other cases which are related to this, and we even have an issue as to who the tank team's going to be for DA Morrissey's communications, because it can't be the DA's office, i.e. Hank Brennan. If Judge Bev was really trying to dispel the appearance of her colluding with the prosecution, this is not a great way to go about it. All that aside, Chief Judge Dennis Saylor received notice of appearance by Caleb Schillinger on behalf of the Norfolk Superior Court on the 26th of February. So naturally, my first question is, why didn't Chief Judge Dennis Saylor notice that the DA's office is improperly interfering in a federal matter? It turns out it's because the federal courts operate on an adversarial system, meaning judges do not investigate issues sua sponte, which means on their own initiative. So, if no party raises an objection to Schillinger's representation, the judge may assume that it is proper unless a clear violation is apparent on the face of the record. So essentially, if Schillinger's appointment as Special Assistant to the Attorney General was formally approved by the Massachusetts Attorney General's office, the federal judge may assume it was done in compliance with state law. So essentially, someone needs to make the federal judge aware that Schillinger is actually an assistant Norfolk DA defending the trial court. Unless it's explicitly raised, the judge may not realise that Schillinger's appointment is problematic. Thankfully, the notice of appearance is only a procedural step notifying the court that he will be representing the trial court. But the defence really needs to object, like soon as, and raise conflict of interest and separation of power concerns. Alright, stop freaking out, Aussie, and explain this in a logical manner. Let's start with why this is improper. We all understand conflict of interest, right? Schillinger is an ADA for Norfolk County, meaning he works for the same DA's office that is prosecuting Karen Reed. He has a direct stake in defending the prosecution's actions, making him incapable of providing neutral representation to the court. A lawyer representing the trial court should be neutral, whereas Schillinger has an incentive to protect his office's interests and continuing to prosecute Karen Reed. So of course he's going to fight for all 3 counts to be retried. The problem with that is it violates separation of powers, because the district attorney, the executive branch, is representing the trial court, the judiciary, in a matter where the court's impartiality is in question. Normally, state courts are represented by the Attorney General's office, that's proper, not a local prosecutor's office, that's improper. And more so when it's the same prosecutor's office who has a vested interest in the outcome of the federal case. This little arrangement makes it appear that the prosecution and the judiciary are working together, undermining the independence of the court. Bev's court, no less. It's also an improper assignment of the Special Assistant Attorney General title. If anybody wanted evidence that Andrea Campbell is also batting for Michael Morrissey, here it is. Schillinger is still an assistant Norfolk DA, meaning he works for Norfolk DA Michael Morrissey, who has been accused of misconduct in this case. Being named Special Assistant to the Attorney General does not remove his conflict of interest. It simply gives him a new title while he remains a local prosecutor. SAAG designations are typically given to outside counsel or subject matter experts, not to the prosecutors handling the case under review. This undermines due process and the integrity of the habeas review. Habeas petitions are meant to provide an independent federal review of potential constitutional violations in a state criminal case. The same prosecutors accused of violating the defendant's rights should not be the one defending the legitimacy of the trial. This creates a procedural taint, making the habeas process look unfair and biased. And finally, it's a potential violation of judicial conduct rules. If the trial court knowingly allowed Schillinger to represent it, despite these clear conflicts of interest, it could indicate improper coordination between the judge and the prosecution. If there ever was something that should be investigated by the Massachusetts Commission on Judicial Conduct, it's this case right here now. Just based on his lack of neutrality alone, Schillinger needs to be disqualified as soon as humanly possible. If I was Karen Reid's defence, I'd be raising the issue in the federal habeas proceedings pronto. But I'm also really pissed, so I would probably file a complaint with the Massachusetts Board of Bar Overseers and reporting Schillinger's conduct as it relates to conflicts of interest under Rule 1.7 and 1.9 of the Massachusetts Rules of Professional Conduct and misrepresentation of his impartiality as SAAG under Rule 8.4, misconduct. But I'm petty like that. The defence may not be. I would be considering subpoenaing communications between Judge Bev and Schillinger, the Norfolk DA's office and Judge Bev, and the Norfolk DA's office and the Massachusetts Attorney General office, and possibly even communications between Andrea Joy Campbell and Schillinger himself. Because if they don't, then they are introducing prosecutorial bias into the habeas review as well. If the defence wants to make the argument that Massachusetts courts are not providing a fair process, then this is a very good example. What the federal court doesn't want to do is blur the line between the judiciary and the prosecution. That is, the trial court judge is supposed to be a neutral arbiter, not an advocate. And the Commonwealth prosecution is supposed to be a party to the case, not a legal representative of the judiciary. And the appointment of local Norfolk Assistant District Attorney Schillinger to represent the trial court creates an appearance of impropriety and bias because it further intertwines the prosecution with the court's decision-making process. And all of that reinforces the concern that Judge Cannoni has not acted independently, especially given her past possible alleged ex parte communications with DA Morrissey. Nor do the federal courts want to support any suggestion of institutional bias in favour of the prosecution. The fact that Schillinger, a current Norfolk ADA, was selected to defend the trial court strongly suggests that the trial judge and prosecution are operating as a unit rather than as separate entities. This undermines the legitimacy of the state trial process, for obvious reasons. The judge is supposed to be neutral, but now has a prosecutor defending her rulings. And the defence is challenging the trial court's fairness, yet the very office accused of misconduct is defending the court's actions. All this on the back of not knowing whether there were ex parte communications between DA Morrissey and Judge Cannoni. which absolutely do suggest improper coordination between the bench and the prosecution. Now, the prosecution has literally been appointed to defend the judge in federal court, and this raises serious concerns about whether the judge and the DA's office coordinated this appointment to protect themselves. Hopefully, a federal judge reviewing this habeas case may find that the combination of possible ex parte communications and this appointment demonstrates systemic judicial bias. And that would be all bad for Aunty Bev in the second trial. I mean, I get it. Maybe you just want to give them enough rope to hang themselves. But this is the last level of relief. All you've got left after this is SCOTUS. Now might not be the right time to slack off the rope. I am so mad, I want to smack my binder on the podium really hard. You should be ashamed of yourself, Andrea Campbell.